This is House Corrections and Institutions. We're continuing our afternoon meeting on Thursday, 23rd. We've shifted gears and we're going to get a walkthrough on a piece of legislation that we passed last year to put in law, which is, it's no gas.
Oh, could be me.
No, it's diesel. It's not diesel. It's the generator running.
Oh, yeah,
That's not
no,
diesel.
that's not me, yeah.
We're on you.
If you wanna, yeah, I don't think if you're.
We put in place a new program on the front end of the criminal justice system for supervision. We have Judge Zone with us. Welcome back. You helped us on this language. We also have from corrections, in addition to Howie Summers, we have Al Cormier. Welcome, Al.
Thank you.
And we do have a new committee and you'll get to know us and we'll get to know you. The concept of the pretrial supervision program. Right now, when someone is arraigned, they are charged by a local law enforcement officer. That charge goes up to the court. Judge's going to correct me, I'm sure. That charge will go up to the court and will be arraigned at court. The judge at that time will determine, does the person go back into the community with conditions? It could go back with bail, person makes bail, or they could go back with no bail. There's conditions most times to that release with a date to show back up to court for their sentence. That's a simple. When
I
there,
just did a presentation on that too, if you guys want me to just throw that in.
am I right so far? Am I okay? So
Yeah.
sort of, I just keep it a high level.
That's right.
So when a person has been released on personal recognizance from the court, they have conditions. You can't go somewhere, you can't drink, the court sets those conditions. And they're out in the community, they're not being supervised. They're just out there. Law enforcement, local law enforcement might see something that's like, oh, wait a minute, this isn't right, blah, blah, blah. There's a violation there, maybe, if law enforcement knows. But there really isn't much supervision of that person. They're out in the community with conditions, waiting to go back to court, basically for their sentence, court date. What we put in place here is called pretrial supervision program. And it incorporates DOC sort of supervising these folks. And they can do it through different methods. They can do it through checking in with the person, maybe once every week, once every other week. They could do it through telephone contact. They might do it through an electronic bracelet, maybe. It would be our PNP officers, I'd still call them PNP officers, at our field offices. It would cost about, last year was over $1 million. Now it's 2 million. It's about 1.5, 1.3 last year. Now it's 2 million. The appropriations committees at the end put about 650,000 to get this program up. It was agreed to during the summer and fall with the Legislative Oversight, Justice Oversight Committee, along with DOC, that we have 2 counties as pilot projects, sort of, to start this program up, which would be Essex County and Orleans County. Because the big shift is now these folks would be supervised in the community with DOC folks, which is different than what has ever happened before.
Mhm.
Okay, so that's the big concept. And Ben's going to walk us through the nuances of
I
it.
feel like you've done my job.
Yeah,
She does that.
Yeah.
I have the background information.
What was the second county?
Orleans.
Just want to give them the background information because you're going to go into deeper depth.
Yeah, yeah. So for the record, Ben Novogroski from the Office of Legislative Counsel. Madam Chair did a good initial overview of the program. Couple terms that I'm just gonna throw at you, see if you know. What is an arraignment? Not all at once.
Yeah.
No judges.
Come on, guys.
No judges on this one.
Connor, Mary,
No, I wasn't.
In fairness, he didn't ask us to define it. He said,
I'm waiting to hear
I can
the,
give it a good
I'm waiting to hear.
Yeah, I wanna hear Representative Sweeney. Let's go for it.
What is an arraignment?
Yeah.
My guess is it has something to do with, somebody being, who's been arrested
Mhm.
and being told when they're going to meet or going to their next, what judge they're gonna see or where they're gonna go to the next, level, the next step.
Kind of, yeah.
That's a guess.
Is Representative, are you?
You're formally charged, when one is formally charged.
Yeah,
with
it's typically,
Crime or crimes,
yep,
then makes an initial plea.
yeah, that's pretty much it. So it's the first appearance, typically first appearance in front of a judge. You're formally read the charges or unless they're waived, and then you enter a plea. So it's kind of what sets the stage. Now, at that hearing is typically when bail or conditions of release will be imposed. The primary purpose of bail is to secure someone's appearance in court. It is not public protection. It is not to punish the defendant. Now, there are public protection mechanisms that can be imposed through conditions of release, but the initial analysis through bail, which is defined in Vermont statute as essentially a security that can be in cash or whatever to secure that appearance, and that can be done under there can be secured bonds, unsecured bonds, sureties, ways to ensure these court appearances. So there are conditions of release that are imposed initially that are related to bail. And then if those conditions are insufficient to protect the public, then you do a secondary analysis of imposing conditions related to public protection. But the primary purpose of bail is to ensure someone's appearance at court. So I think that's just sort of a good primer, if you will, that sets the stage for this. So one of the conditions of release that was enacted last year, it's a new addition to 13 VSA 7554 and governed by 7555, is the pretrial supervision program. And now this program, like I said, can be imposed as a condition of release under the bail statute, and it can be imposed as a condition related to bail or as a condition related to public protection. Now, only certain defendants are eligible for placement in the program. It's court ordered, so the court determines whether those eligible individuals are suitable for placement into the program. And it's administered by the Department of Corrections, meaning that they're the ones, boots on the ground, supervising these individuals. And there are various supervision levels that can be imposed, and it's determined by an initial assessment that DOC does and submits to the court. And then there's also a compliance and review procedure for individuals that may not abide by the conditions of their pretrial supervision program. So it's very general, and then we're going to get into the details of the different parts of the program. But any questions at the outset?
Yeah, you get two arms up. I see that. I'm going,
Stretching, you don't blame it on the rotator cuff, though.
That's what it is.
Yeah. So the governing statutes, as I explained, is 13 VSA 7554. This is what a lot of prosecutors will refer to as their Bible, because it really governs everything about bail, how to impose it, the factors the court that considers, the options that are available, what happens if bail conditions aren't met. It's everything. And one of those conditions is this program. So again, there's a very short overview, but the court assesses various factors to determine if pretrial release conditions need to be imposed. Number one is risk of flight, the seriousness of the offense, how many offenses with which the defendant's charged, current conditions that are already imposed for pretrial release, probation, furlough, parole, or another type of release, compliance with court orders and appearances in a criminal prosecution. So those last three factors were new last year. There was testimony saying that a lot of judges already use those factors because there's sort of a catch-all provision in 7554 that says any other factor that the court deems relevant. Many of these are relevant in the court's assessment, but for consistency purposes statewide, the legislature determined it was good policy to memorialize these new conditions so that they're reviewed every time it's someone is before a judge. And other ones that are considered character and mental condition of the defendant, ties and length of residence in the community, the record of convictions, and like I said, that catch-all, anything else that's relevant. Pretrial supervision was a new condition that was added to those that could be imposed, and it's governed by 7555. And the purpose of the program is to assist those using evidence-based screening procedures and strategies to improve pretrial compliance with those conditions of release, to help coordinate the provision of support services like substance abuse treatment if necessary, and to ensure court appearances and decrease the potential for individuals to recidivate, to commit new crimes. So that's the general purpose of the program.
The pretrial supervision is a condition that the court can put on the defendant. Kevin,
So it's 2:45 Sunday night. Police officer picks up someone who appears to be selling drugs. Drugs are on the person that's been picked up.
Mhm.
What, may I ask, what happens at that point in time? They don't go before a judge right then for arraignment.
No, so it's fact dependent. So they could be cited for the crime, which means typically a couple weeks out, it says appear at this time and place and at this court. If there's a reason, if there's probable cause, if the officer witnessed it going on, they can be arrested and held.
Okay.
But it's really dependent on what's going on. There can also be a warrant issued by a judge ahead of time if it's part of a broader investigation. So
it's up to the officer.
yeah, in the circumstances that the officer is presented with.
so if the person is held overnight in a correctional, say it's egregious enough, they say, I'm holding in an incarcerated setting. The court holds arraignments as quickly as possible after a weekend for those cases. So the person will show up for an arraignment.
It'd be the detainee.
Well, it'd be a short detainee night if they're just released the next day. But if they end up going back to jail because they're a risk of flight or other circumstances, they have a high bail and they can't make it, or they go without bail and the court wants to keep them incarcerated, there'll be a detainee.
And Representative Winters, just to, because I think what underlies that question is that there's this notion of kind of catch release in the state, right? Well, it's not really, it's kind of a misnomer in a way, because it's not necessarily how the legal process goes. The rule, the overarching rule of thumb, and there are more rights provided in the Vermont Constitution than the federal Constitution, is you're innocent until proven guilty. So if we're going to hold you before your trial in which you're convicted, there has to be a legitimate and compelling reason to do that. And the Vermont Constitution has really only carved out two situations where you can be held without bail. If you've been charged with a crime with a penalty of life imprisonment or a violent felony, but there's still a process and procedure to ensure that there's evidence present to support those charges and to support that really serious deprivation of someone's liberty. So just to say that the legal process is more nuanced than sort of these catchphrases, unfortunately.
And hearing they are detained until they are arraigned.
They can be, it depends on the situation.
They could be cited by the officer to show up in court 2 weeks later.
So for instance, when I was in private practice and I was a criminal defense attorney, if someone was cited for DUI, they're not necessarily arrested. They can be arrested if, until they're sober, and detained until then and then released. But they're just getting a citation for the most part saying, appear in a couple of weeks at this date and time.
And that's one of the issues. There seems to be such a lag time from the time of the actual offense or perceived offense and the citation to show up.
But
It's not immediate, and that's what I think some people get frustrated. Why isn't it the next day?
well, there's a process that goes into that too. So what happens during those couple of weeks is that, so everything is really contingent on the law enforcement officer's probable cause affidavit. So there's a charging instrument that is submitted to the that the state's attorney draws up that says, these are your charges. How do you plead? But that charging instrument, so it's either called an information or an indictment, is always accompanied with a law enforcement officer's affidavit attesting to the facts that establish probable cause, which is that there's sufficient evidence of criminality to charge this person. So that all takes time. So the officer needs to go back, needs to draft that up, needs to attest to it, needs to submit it to the state's attorney. State's attorney now needs to make an assessment there and say, are we really going to charge based off of that? Okay, if I do that, then I need to draw up the charging document, and now we need to schedule it before a court. So there's a whole set of processes that happen within that time frame.
I hear
Yeah. So any other questions before I move on? Thank you. And I'm glad that I have Judge Zone and DOC here to chime in if I make any mistakes. So what is the eligibility criteria for those that are being considered to be placed in pretrial supervision? One, the defendant is accused of violating conditions of release pursuant to 13 VSA 7559. That statute is the criminal contempt statute, so it's its own separate charge. So if someone violates conditions and the prosecutor says, you know what, this is serious enough for me to bring a separate charge, they can do that. So it's someone that's been accused of criminal contempt, essentially. So they're now eligible to be placed in the program. Or if they have at least 5 pending court dockets against them. So if they went on a spree of criminality in the past month and they had 5 different run-ins that yielded 5 different cases that are before the court, they could potentially qualify.
So if it's your first time offense, you wouldn't qualify. Your first time offense, and you were released in the community, you had conditions of release on that. You abided by those conditions, you showed up for your court date, none of that would apply. The pretrial supervision wouldn't apply to you. But if it's your first offense, court releases you with conditions, and you violate those conditions, or one of those conditions, go back to court, court could say, you know, we gave you a chance, but you didn't abide by what you agreed to for your conditions. We're going to place you on pretrial supervision, which is the next level where you're actually going to be supervised by DOC staff, where before you had no supervision. You were on your own.
But they may, correct? It's not that they shall under these
Yeah,
circumstances.
the legislature can't tell prosecutors what to do. It's a separation of powers issue. So the prosecutorial discretion is very
Separate
held.
branch of government.
Yeah.
It's up to the courts.
The Department of State's attorneys and sheriffs will be happy to tell you about prosecutorial discretion.
Mary?
So what about the folks that we read in the papers that have 100 different things that they've done, crime,
Well,
and they're out on the street? So how does that kind of?
so they would potentially be eligible. It's a possibility, not, just kind of taking it at face value. But the other thing to keep in mind is that this is a brand new program. It just went live at the beginning of the year. And there's only enough money and staffing to fund 2 counties. So the limited, because it is a statewide program, but there was a provision inserted that's saying basically if it's not funded, it can't be ordered in your county because there's an obvious conflict with that. So potentially those people could be brought into this, but which they're, since it's new and not really fully implemented yet, there are some, clear limitations so far.
Just to refresh my memory, the 2 counties are.
Essex and Orleans.
We only had
Rest
about
of you too bad.
Right, because we only had about 650,000, and it's a cost to DOC because it's a cost to their field office.
Well, and testimony last year was that I think the initial ask was for 12 new probation and parole officers plus 2 support staff. That was revised down to 6 and 1, and ultimately I think they got 2.
Al, do you know how many?
We have 4 referrals. Oh.
But as far as the staffing, it was 12 and 2, then 6 and 1, and then was it ultimately just 2 new positions?
3
Yeah.
positions.
3 new.
Yeah.
Five positions with funding for 3. That's what we got.
So there you go.
And if we want to expand it to other parts of the state, we're gonna have to find money in the general fund budget for DOC to do that.
And, you know, the department testified last year that, you know, right now it seemed that the PMP officers are probably the most readily trained to do this. And there are what, 12 districts around the state? And so essentially the request was 1 new position per district
With 2 administrative.
with 2 administrative staff.
You already, Al Cormier, you should identify yourself for the record, but the folks you've already had the authority to hire, those 3 folks, that would also, they'd also cover the statewide system if we got that in place, correct?
Yes, and Al Cormier, Chief of Operations for the department. So, yes, I mean, that's the ultimate goal. I mean, right now, we only have the 1 position we've hired in the new board PMP office. So we've started that process. We've gotten the allocation for a 2nd position to expand to Caledonia County and St. Johnsbury Probation Parole. So we're already looking at the expansion model, but in order to go statewide, we would need all of those positions. One of the things we ran into last week with one of our referrals was they had 5 dockets, but 1 docket was in Orleans and the other were in Bennington. And because of the language around if it's not offered in your county, so we couldn't take that case.
Interesting.
The different. county.
Where was the referral?
So it should have been up there. Gone, it's
But it
not,
was only 1
That's what I
docket.
heard. But that was what I was referencing, because I
It's
thought
not
it
offered in
was.
Bennington County. We have nobody supervising Bennington County.
So it would have to have been 5 in Orleans and or Essex?
Well, or at least that's an interpretation.
That's how it's being interpreted at
Oh,
least.
I was,
Yeah.
I think you could have another reasonable interpretation too. But
lawyers argue.
you also don't wanna, yeah. I understand, yeah.
Who's the person resided in Bennington County? So.
Practical.
Yeah, if they resided up in Essex, it might have been a little different. Any questions, other questions on these eligibility criteria?
Always fun when you learn how your language is being implemented.
I was just gonna say, I didn't want to go down a rabbit hole, but that's a good lesson, especially for new people, how the intent can be interpreted in a different way. You know, and whether it's right or wrong, by the way, it doesn't matter. It's that you can have a clear intent, or think you have a clear intent, and it could be interpreted a very different way. So,
So
you know,
that-
we have to look at it again.
So that's why sometimes we have a statement of intent. And it's also, all of these proceedings we have in committees are recorded. And if any issue comes up before the courts, and the court says, what's the legislative intent? All of our proceedings are recorded. They can go back to those recordings to hear the committee discussion, hear the committee testimony. But particularly in discussion, when you're marking up the language, when you're putting the bill together, that's where your legislative intent really comes into play. And the courts go back to some of those to really find out what did the legislature intend with this language.
Only if the provision is ambiguous. But yes, it's possible.
It's possible. So everything we do is recorded. In case, I mean, in the old days, we had a tape machine in the middle of the table. And it was stored at the archives because you needed legislative intent. Particularly when you have committee discussion. That's when your legislative intent, what did the committee intend?
Well, and the way that that would be implemented in practice is through motion practice between the attorneys. If, let's say, the prosecutor really wanted pretrial supervision, the prosecutor could go pull the tape and said, no, it really was meant to be statewide, or the defense attorney could say, I don't know that what it says, and so then you get into basically a paper battle in court, and then the judge ultimately makes a decision either on the papers or holds a hearing.
Okay.
Let's keep going. So what is the procedure to place people in pretrial supervision? So it can either be done at arraignment or another hearing that the party or the court, so that party means defendant or the prosecutor, or the court itself, so the judge, may move that an eligible defendant, so someone with 5 cases or someone that's been accused of criminal contempt, be reviewed to determine whether placement in the program is appropriate. That review is scheduled upon receiving a report from DOC containing the recommendations about the defendant's supervision level. The court then reviews that report, schedules the hearing, and then they do an assessment to determine if placement in the program will reasonably ensure the defendant's appearance in court when required, will reasonably mitigate the risk of flight, or reasonably ensure protection of the public. So those are kind of the 3 overarching things that the assessment needs to be tied to. If we place them in the pretrial supervision program, is it serving one of those 3 goals? So the court considers the nature of violation of conditions of release, the nature and circumstances of the underlying crime for which they are originally arraigned, their criminal history, essentially mental health needs, history of supervision, risk of flight, prior convictions, any violent history they may have, and then any risk or undue burden to third parties or risk to public safety that may result from the placement. So, if they are placed in the program and there's a real concern that maybe they're going to go after the alleged victim of the crime, maybe they're not appropriate for it. But it's all weighed against these other factors, and there's a sort of essentially a cost-benefit analysis that the court does. And then finally, sort of the catch-all, anything else that's relevant in the eyes of the court. So that's the initial assessment of eligible individuals. So you need to meet eligibility, then you need to be assessed by the court through the report submitted by DOC, and then the court issues a decision whether to place them in pretrial supervision or not. So what are the supervision levels that DOC can recommend and that the court can order? There's a telephonic monitoring system. So these would be like automated calls that someone receives on their cell phone to say, appear at court on this day at this time. So it can be something as minimal as that. It can be telephonic meetings with a PNP officer. It can be an in-person meeting. So you have to actually show up, and that way they get to kind of size you up and see how you're doing and all of that. Or it can be electronic monitoring. So those ankle bracelets, this is also employed in the home detention program. So if you have a bunch of restrictions placed on you through those conditions of release that you can't go within, say, 100 feet of someone's home, or you can't have contact with a certain individual, an electronic monitor will help ensure compliance with those conditions. And then you have a probation and parole officer potentially reviewing those records as well. Or any other means of contact deemed appropriate. So that could be anything like a Zoom meeting or some combination of these supervision levels.
Who determines the supervision level? Is it DOC or is it the court?
So it's recommended by DOC and then ordered by the court. So there is discretion there to either just adopt those recommendations or maybe do something different.
Or a combination thereof.
Mhm.
Or, I think we talked about this, they could start out with a telephone meeting for pretrial supervision. The person maybe shows up the first time, but doesn't show up after that. So then you'd have I would think DOC needs to go back to the court, or DOC could then say, whoops, we're gonna put you on electronic.
You know what, Madam Chair, I'm glad you asked that question. Because then there's compliance and review. So what are the procedures for that? I know you do. I knew you were leading me to that. So there's discretion, or there's not discretion when it comes to certain conditions and discretion when it comes to others. So pretrial officers must notify a prosecutor and use reasonable efforts to notify the defendant of any violations of court-imposed program conditions. Because there are going to be the court-imposed conditions. So if there's electronic monitoring, or if you're supposed to appear and meet with your officer and you're not doing that, and those are ordered by the court, the officers have no discretion, must report those to the prosecutor. But then there are administrative conditions that DOC can set. So for instance, and I might need your help here, but like if you don't charge the battery of your electronic monitoring device and it goes dark, that's sort of an administrative requirement of being under electronic monitoring. So if you don't do that, then there's discretion on the part of the probation and parole officer to notify the prosecutor and defendant. This was a policy decision that was made by the General Assembly last year based on testimony that, the court ordered conditions must be reported, but those administrative ones, given that there might be a relationship with the officer, they probably have some knowledge about, is that true, is that not, can make that call. The parties or the court may move for the court to review the pretrial supervision conditions. And that can be done through the prosecutor possibly filing the pretrial supervision officer's sworn affidavit with the court to arrest someone that's violated conditions, or someone that's committed multiple violations of supervision requirements or has fled, absconded. So that only happens in those situations. Prior to that, if it's just a breach, like maybe you didn't show up to court and this could be a wake-up call, then you go to this point here. Oops. Don't mind me. Then you go to the third point, is that now there's discretion to schedule another bail review hearing to say, you know what? We want to hear what happened. We can issue more stringent conditions if we want, or you know what, maybe this was a one-off thing and they're good. Something happened that we weren't aware of. Maybe your car broke down and that's why you didn't make the court appearance. So it gives the discretion, but if they've fled or they've committed multiple violations, then you can issue an arrest warrant for them. So there are policies and procedures that were required to be created. So by November of last year, DOC had to establish written policies for the program produced by the department and anyone else that the department engages with to assist with the monitoring operations of the program, and also to assist the courts in understanding the inner workings of the program itself. You'll probably hear testimony at some point from the department about electronic monitoring and the difference between active and passive monitoring. Passive monitoring isn't exactly real time. So for instance, if someone violates the conditions of their electronic monitoring over the weekend, DOC may not know about it until Monday morning when they go back in and check the system. So there is flexibility here for them to contract with a third party to help with that monitoring if need be. But these written policies and procedures would establish what that monitoring would look like and all the details of that. They also must develop policies and procedures concerning those supervision levels, the criteria and the evidence-based mechanisms that were used to determine the appropriateness of each supervision level and the means of contact that's appropriate for each level. So really building out those details of supervision.
I do have a question of DOC before you go down. Did you have time to establish your written policies and procedures, and you met the deadline on November 1st? Okay.
And then on this third point, you'll see the program support that I referenced. There was a lot of discussion about who and what entities should be eligible to essentially be contracted with. And it was decided that public entities that meet the criteria established by DOC are ones that can be contracted or issued grants to help assist with the program. And finally, it's contingent on funding for it to operate, as we've discussed.
So this is a new condition that the someone whose program for supervision in the community. We don't have this now. So there's some pluses and minuses to it. And that's what we discussed last year when we were doing this. Pluses are they be supervised while they're in the community, at least some level of supervision, which would provide some public safety. The flip side of that is we could be violating folks for a lot of violations of conditions that will then keep them in the criminal justice system and may escalate folks coming through, more court time, more time for prosecutors and defense. So it could be a cost increase there because they're now using the court system where in the past they wouldn't have because they wouldn't have been caught. So that's the balance. Al?
I would add to that, that two of the referrals that we've received have been of individuals that are currently incarcerated on bail. So there is also that potential to decrease that detainee population through this process if they're found to be eligible for pretrial supervision and could potentially lower that detainee population if the court agrees to reduce the eliminate the bail.
Right, that was my question. If you're having bail and you don't make bail, you're gonna be incarcerated. If you make bail, you're gonna be out in the public. For bail is imposed. Questions, Sean?
What is the cost?
Yeah.
I guess, per person to
Implement the program?
to implement like what is it? For each of these counties, what are we running into? How much does it cost
We're looking at statewide close to $2 million.
per year?
You're building your base of your DOC budget.
And that's DOC costs. You know, there are potentially judiciary costs, but
Staffing, IT equipment,
Yep.
administrative costs, vehicles, additional vehicles for
Doesn't sound too bad.
Well,
On the DOC side of things, I'll let judiciary figure out their budget, but on the DOC side of things, how many people does that you're, no, yeah, I'm not saying you're welcome to you, but you're welcome, Judge Zonak. How many people would that most likely help or be part of for that 2 million?
Well, I think the last numbers we had during joint justice were approximately 800 people statewide that were eligible for the program.
100?
800.
800.
so you're gonna, with 800 people, you're gonna pick up a lot of violations. That's gonna go back to the court. But the flip side, you may provide a lot more public safety.
and also to factor in, and this is just from the public safety presentation this morning, is that there are about 530 currently detained. So that's another factor in that whole equation.
If you could pull some of those folks who are detained.
And assuredly, there's some overlap between those that would be eligible and those that are detained.
And more?
I have another
Yeah.
question. So, okay, so I kind of got lost with that 500. You said that would be in addition to this 800 or no, it's part of the 800 that are eligible?
I don't know if there's a direct
Okay.
but there could, I would think that
Not
there
mutually
is,
exclusive.
right, exactly.
Okay.
Thank
And
you.
so then going back with so then going back to DOC, I feel like one thing you guys have mentioned that's been difficult is having the detainee population mixed with the incarcerated population. Or maybe I'm using those terms wrong, but would this assist DOC with that, make it a little more focused on people that are sentenced? That's what I'm
Well,
sorry.
I mean, it's potentially, I think it's still too early to tell. I think the 530 or so that we have detained right now, we don't know if all of them would be eligible based on the 5 dockets of violation conditions. somebody could have 5 charges, but 5 charges does not equate to 5 dockets.
Right. Because, and the way that that works is that sometimes there can be one incident that yields several charges and will all be assigned one docket number in front of the court. So that's why they're not necessarily, it's not a nice overlay there.
Thank you.
But it's plausible then that some current, the 500 some odd detainees may be eligible for the program and then not have to be detained.
Correct.
Sorry, I decided to repeat for my own
Yeah.
understanding.
You know, it's a new program. We just don't know how it's gonna play out. It's a first-time DOC staff is supervising folks in the community that have not been sentenced. So it's a shift for DOC. Kevin,
There must be a record of defendants that have fewer than 5 pending court dockets. Because you have to know that there's 5 before they can be eligible for the program. Any idea how many of those people are out that have got 4 or 3 or 2?
That would probably be a question for other department of judiciary.
I mean, my point is that to me, to get to 5 dockets, that'd be a pretty bad hombre, don't you?
Not necessarily.
No?
You might have committed bad acts, but you can be a decent, good person, just made,
a lot of
you,
choices.
for example, you could be like have an addiction, right?
You've broken the law.
That's a better way to put it. You-
Yeah, I'm not.
Yeah.
Yeah, we're all bad.
Yeah, well,
It's like, I mean, this is
I am.
5 times the court has said, show up because you've crossed the line, right?
Mhm.
I guess that's what my impression is. So I don't want to quibble with the 5. My point is that there's probably numbers of people that are close to this line that are reoffending.
Mhm.
And if they are violent offenses, I'm wondering if we're not being too lax.
Well, A, that's a policy decision.
Yes,
Um,
agreed.
and,
Do we
and
have that information? I guess is what I'm asking. It's because if there's 1,500 people that are at level 4, but they're not eligible for the program because they haven't hit the magic number 5.
I can't speak to that.
No, I understand.
Yeah,
I'm
yeah.
not, I'm just saying that.
But I mean, there was this discussion last year about choosing 5.
Yeah, yeah.
And if I recall correctly, what the committee's discussion centered on was, you know, kind of the threshold amount for people that were serious enough offenders, but not overloading the system.
Right.
And so 5 was
Yep.
the policy choice.
Okay,
Yeah.
I get you. I'm just
Yeah.
saying, we must have a record of this and to understand how much of a population there is that are not falling into this eligibility would be helpful.
But then if these are violent felonies,
Yes.
then they can be, this is part of the other presentation I gave. You can hold them without bail. If it's a violent felony, the evidence of guilt is great. There's clear and convincing evidence supporting that. And there are 2 other conditions that I can't recall off the top of my head, but essentially what happens in that situation is someone would be arrested, detained, arraigned, and then within about 2 weeks, this hold without bail hearing would be held to litigate that issue. And if the court decides that they should be held because they meet the standard, then they're held. And then within 60 days, a trial is scheduled.
Right. And if they don't show up in the 60 days,
Well, they're going to be held in
Oh,
that, in
they're
that
held, I'm sorry.
situation.
Yes,
Yeah.
yeah. so then my logical question then is, this all sounds great. And yet, our governor is saying we have repeat offenders that we need to tighten up on. And editorial comment, I don't think he's blowing smoke. And the public feels like there's too much reoffending. So something doesn't seem to match up here. This sounds like a great system. But public perception and even our governor doesn't feel the good effects of this.
Well, I'm not going to speak to any of that, but just the facts of this program is that it only started January 1st. and it's only in 2 counties. So that may affect.
3 weeks.
No, I agree.
Yeah.
But even before this, I mean,
Well, and just to go back to what Ben said, because I think it really needs to be hammered home. When we're asking questions or things to make sure, like Ben can't talk about policy issues. Like we can as a committee, but be careful where we're asking questions.
absolutely.
Experts like this will know they'll say, hey, I can't answer that, but like, we don't want to put anybody in a spot to answer questions. They're not
Absolutely.
supposed to ask.
No offense.
No, it's all good. I appreciate it, but I'll be the first to tell you when I can't answer something.
Do have Judge Yone here, and he's more than welcome to weigh in at any point in time, if you wish.
I do have a few comments.
That would be great, and
Yes,
then
sir.
we'll go to you.
Oh.
Okay.
Thank you very much.
Yeah, of course. My pleasure.
I mean, it's here,
Whatever works.
you see how quickly he's leaving.
The seat is hot.
Yeah. It's just.
Nice to have you on, Tim.
Yeah, yeah, you've got a
Get out of
red line.
Oh, I know that. Let's get to the red
So
line.
good afternoon. Pleasure to be back. Tom Zone, Chief Superior Judge. The answer to your question is 11. There are 11 defendants in Orleans County who have 4 criminal charges and didn't meet the number 5. There are 21 who have 5 or more. There is one who has 4 in Orleans County and what Mr. Cormier mentioned, 1 in Bennington County. There have been 4 requests. The judge, I believe, the court had sent over the request to DOC. 2 of those have been deemed not qualified by DOC. The other 2 have not yet come back yet. I do know that on the issue of whether or not there's a 4-in-1, how that goes. If that's a reason, my assessment is that that's something the court will have to decide. DOC may say, we don't read the statute that way, but the statute vests the authority in the court to decide whether or not someone qualifies. So a judge could decide that no, he or she reads 7555 subsection G to mean that as long as you're living in a county that has it and you have 1 charge here and it's on that condition, a judge could find that way. A judge could find that no, they have to all be in the same. So that's statutory interpretation, and that's what some of the areas that we're going to see play out here. I would expect that you're going to see more referrals made. My understanding is that in Essex County, they did a bench bar and that they're going to start working on it there, but the numbers in Essex are so much smaller than Orleans. But going forward, we'll see how it plays out. It is obviously, no one's participated in it yet, so we can't say whether it's successful. Any idea of rollout would be premature.
Do you have details on the 2 that were denied? Do you know what the rationale was for that?
I believe 1 did not have 5, and I believe the other, I believe they were both did not have 5 or a violation of conditions. And the one I believe was the one that Mr. Cormier mentioned, that it was not 5 in 1 county,
Gotcha.
and there was no violation of conditions.
One individual made bail.
Okay, and one of them maybe. And so the judge could still, in that case, go forward with it. But the discussion that you had is correct, that if someone is in jail on bail, and the judge said, well, I want to see if this pretrial services are there, that may well influence the bail decision. And so the attorneys could say, yes, we'd like this individual evaluated, or the judge can say it. And then they may have $1,000 bail, and a judge says, well, if they don't have this program, they're a risk of flight. But with this program, we think we can manage the risk of flight without bail. They can participate in the program, and then they would not be held.
Well,
So for eligibility for the program, so you said that there's 11 people in Orleans County right now that qualify for it?
No, there's 21 that have 5 or more. I do not have a list of how many of those individuals have violation of conditions, because that's a separate category. The 21, I believe, is what I just counted on the sheet that I have for how many people have 5 or more charges.
Okay, never mind. So then I'll move on to the next part, and that was more the eligibility for this program. Would that be something that's internally worked out between DOC and judiciary, or would that be statutory change?
The court will determine what the statute means based upon the plain language and any other sections of the statute. There are canons of statutory construction. So if there's a question, DOC says, we think it means this, and the court says, what it means. The state may feel it means something, the defense, and so the judge has to make a decision on what was meant by the statute.
Can I just clarify real quick? So Ben had talked about 5 dockets. You just said 5 charges. I just want to make.
I meant 5 dockets. Thank you. Yeah.
Not for me, but just so other.
Thank you. Good point. There could be one case with 5 separate charges in it. This requires 5 separate cases.
Thank you.
Gotcha.
So are the judges receptive to this from what you're seeing?
Yes. I know Judge Tebow, it was Ms. Weber had worked with Judge Tebow and Judge Kanan, and I know Judge Tebow worked with even DOC down to the point of its policy to make sure that it was something that was going to work for everyone. So I think the judges were absolutely on board. And I also think that when you look at the fact that I think it was Judge Tebow who made all 4 referrals, not even the state or defense, that evidence is the fact that the court does believe this is something that we need to look at in the right case.
How is DOC feeling at this point? I know it's so new.
Yeah, no, I think we're good. We're excited about it. I think that last referral will be a positive recommendation to the court, because it could be appropriate for posting on pretrial. See where that takes us, but and then our intent in starting in Orleans and Essex is because it was small. We want to work out the kinks and get it right. So far, I feel like we're doing that.
And are you getting any pushback from your field offices at all or staff? Because I know I spoke to the folks down in Springfield and they said, yeah, we could just possibly absorb this within our current structure.
Yeah, that's something we'll have to look at it as we build this out further and get an accurate count and potential numbers, but. Yeah, I think all of our field sites are willing and expecting to take this on.
And also another positive of this is if these are low-level violations of conditions, we could intercept and prevent an escalation of poor behavior.
This presents an opportunity not just for that, which, yes, if someone has that, we hear about what's called a sequential intercept model, and that's where on the continuum can action be taken to stop it from going forward. And so if you get someone at the lower level, that's certainly something that can stop them from going forward. Also, if you have someone who might be high risk and high needs, this program is something that brings with it the potential to address those risks and those needs, because this is supposed to ideally get them the skills and monitoring to meet with success for their risks and their needs. But I think you're correct. I think it's on both levels of the both ends of the spectrum. It brings with it the potential for increasing public safety.
Thank you.
So the key will be, we had 650,000 that was put in the budget for this. That's for 1 year. It's a 1-year budget. The question will be, is the governor going to recommend more money to go into DOC's budget to cover the expansion of this? Did we have a time frame on that pilot project? I don't think we did. It was basically 650 for 1 year.
Yeah, I mean, under the statute, it's not a pilot project. It's just.
You roll it out
Yeah.
as you have the money, you roll it out. So it will be interesting to see if the governor proposes an increase to the DOC budget for this particular program. For that, but just wanted to give the committee some background on this in case this comes up. But this is a new initiative that we spent a lot of time in here last year working through this. It's
Basically just sprinting between this room.
went back and forth. That's what we end up doing. And anything else?
That's what we have, and look forward to reporting back on what happens with the program as we go forward. So I'll make sure that I keep track of it. So if you want updates at any time, please just email me and say how many are in and what's going on, and I will be able to get you that information right away.
Great, thank you, Judge.
Thank you.
all.
Have a great day.
Thank you.
Thank you, folks. We're done for the day. It is Thursday. Tomorrow's Friday. Week went by pretty fast.
9 o'clock tomorrow?
No, we're in after the floor.
Right, Florida.
Friday.
Yes.